I want to go ahead and welcome everybody and apologize for the 25-minute delay. As Andrew said earlier, we've had some technical difficulties, but finally got them worked out. So thank you for your patience, everybody who waited. This will be rebroadcast for those who didn't wait, but I do want to welcome everybody and let them know that right now we are live, and we will be offering a replay later on, and we'll send you an email on how to get the replay. And as long as you're following me on Periscope, and I'm at Mr. Land Trust, you can always get any of these broadcasts replayed because they'll be on my account there at Mr. Land Trust. Now, for those folks that are new to Periscope, and I know many of you are, you can chat with us. You can't talk to us, but you can type in your questions, and we will be monitoring those as we go through this explanation today. So if there's something you want to cover in a little bit greater detail or something you're not understanding that we're talking about, just type in the question. It will be, it'll pop up on our screen, and we'll try to monitor that as best we can as we're going through the materials today. A lot's happening on Periscope all at one time, so please be patient with us. Not only are people signing on, typing in messages, but they can also hit the lower right-hand corner of their screen and send us hearts, and we'll talk about that in a minute too. Also, if you folks that are watching, if you think your followers on Twitter and Periscope need to learn what we're teaching here today, by all means share it with them, and you can do that on Periscope. There's a share option. And one other thing, I do have a goal of 5,000 hearts this month, so if you hear something you like, please be generous with your taps. And for those of you who might not know how to do that, you create hearts by tapping on the lower right-hand corner of your screen, and that will send up a bunch of hearts, and those give us credit as far as Periscope is concerned, as far as our popularity. So, yeah, somebody's shooting the hearts up now. We appreciate that very much. And who you see on the screen right now is my guest speaker, who is Lynda Sands. She is in San Diego. She has a company called Asset Century ALC. And in addition to being an attorney, Lynda has her master's degree in business administration, and she's known by many people all around the country, but specifically in California as well, as a leading attorney in North America on philanthropic transfer of wealth, which is a very specific area of the law. Lynda's individual clients often are highly successful real estate investors, CEOs of closely held companies, or people with personal net worth of $5 to $100 million. So she's dealing with the big boys. And she works with them to achieve asset protection. So I'm very honored to have you on our broadcast today, Lynda, and thank you very much for joining us.
Thank you.
And if, as we're talking today specifically about the land trust, since all of my students have the land trust agreement and have been working with that either over the last 2 weeks when they just purchased the program or maybe the last 2 years, I thought it would be a great idea for us to take that trust agreement, and that's the 5.0 version, and break it down paragraph by paragraph. Now, you know, it's 30-some pages long, so we're obviously not going to be able to go through all the paragraphs today, but my goal is, probably between now and the next several months, is that Lynda and I get on and do these broadcasts every week or two, and we'll cover paragraphs beginning on page 1 of the 33-page 5.0 version of our trust agreement.
And this will go on until what, 2020?
This will go to 2020, and we should be done by then, if we all live long enough.
Yeah.
So, for those of you who have access to the 5.0 trust agreement, if you either have printed it out and have it in front of you or have it on your computer screen, it might make a lot more sense to you as we're discussing this. So our goal today is we want to cover on the first page options 1, 2, and on the second page of the trust agreement option 3, because they all relate to how to start creating your trust agreement. So I'm going to turn it over to Lynda right now. And Lynda, you know we've got option 1, 2, and 3. Would you please give us your explanation, your interpretation of when someone should use each of these options and maybe why they want to use one option over another?
Okay, first I wanted to explain when you gave my bio there that for 39 years I've worked in the philanthropic area, but for about the last 15 years I've been working with real estate investors, and in that working with real estate investors, do you want me to pause for a second?
No, that's all right. Go ahead.
Okay. In the last 15 years or so, working with real estate investors, I started out doing that as a real estate investor. And when I went to seminars or conferences, people near me, when they found out that I was an attorney, would say, "Can you do a land trust?" And I'd say, "Sure." And then I'd go to Randy. I said, "Randy, I need help here." So since then, I've been doing land trusts and LLCs for real estate investing. I've been doing IRA asset trusts for real estate investing, which is a special form of a land trust specifically for using your self-directed IRA in investing in real estate. So I do specialty trust work, even things like pet trusts or gun trusts and odd and unusual types of trusts.
Yeah.
But the land trust is a large part of that portion of my practice where I work with real estate investors. Now, when I go through options 1, 2, and 3, I'm going to hope that I explain clearly which type of client of mine uses which option.
Okay.
Because I know it can be very confusing, and maybe we have to tweak the description of the options to make it work. So I'm gonna go over to my trust document here.
Okay.
And let's go to option 1. Now, all of these things are called preambles, and then you get all the different trust terms. And this is what introduces who the parties are and how this got set up. So if you look at option 1, it says if you own the property and are putting it into a new land trust, this is an option that you might use. Now let's take an example. I'm the real estate owner. So if we go through this language, it says this trust agreement is made by Lynda Sands, and now I have to have a trustee. So, Randy, will you be my trustee?
I sure will, Lynda.
Okay, so this trust agreement is made by Lynda Sands and Randy Hughes as trustee. Now, this is assuming two things. One, that I already own the property in my name. It's been recorded at the county in my name. And 2, that I don't mind having my name there because it's already been recorded publicly. So I say this trust agreement is made by Lynda Sands and Randy Hughes as trustee. Now I've chosen my third-party trustee. Next sentence, the real property, trust estate, listed in the schedule of trust property attached hereto, there shouldn't be a space in there, by the way, and made part hereof, shall be held in trust and administered and or distributed as provided in this instrument. So that's the introduction. I'm saying, here are the parties, and this is what we're doing. Then the next sentence says, the name of the trust created by this instrument shall be. Now, you have a naming convention, and I know Randy talks about that extensively in his courses. What is a good name? Should it be words? Should it be numbers? Should it be a combination of those? And then this agreement shall be effective immediately on execution by all parties. Who are the parties? Well, the name of the current owner, we said, was a party, and the name of the trustee is a party. So at the end of this, if you use this option, at the end of the trust, you're going to have the trustee, and you're going to have Randy as trustee, and you're going to have me as the current owner signing that we made an agreement, and all the terms following this preamble are what we contracted for together. Okay, Randy, you want to jump in there and say anything about that?
No, not so far. I think you've done a great job of explaining it. I would mention that probably 80% of the trusts that are created by my students are where they're buying property from somebody else. They're not entitled now. So maybe 20% of them, certainly when they buy the course, they probably already own some real estate in their name, and so they want to get it out of their name and put it in the trust, and thereafter they'll always take title directly from whoever owns it now to their trust and not ever be in the chain of title themselves.
Right.
And so those are the main scenarios, and as we'll get to option 3, we may be dealing with a bank or REO or whatever, but why don't we go on to option number 2?
You have to excuse me. We have a bad allergy season here, and it's attacked me this year really bad.
That's all right.
I always have spring allergies, but this year is really bad. So forgive me if I'm coughing.
Okay.
Did that just show my light going off in my office?
I think it did.
Okay.
Of course, they have the doctor.
I just moved into a new office, and the electrician helped me out greatly by putting in a motion sensor, except he put it around the corner from my desk. So I've called him and I said, you got to come back and fix this.
Lynda, before we move on, people are typing in questions on this broadcast, and a question just came across the screen that do you have to buy the course to get this form? And obviously that's coming from somebody who does not have my home study course. And just to answer your question, yes, all the forms, including this trust agreement, come with my home study course and can be found at my website, which is Land Trusts, with an S, landtrustsmadesimple.com. If you are interested in the home study course that comes with all these forms, including this trust agreement that we're going over. So thank you for that question, and let's go ahead and move on to option number 2, Lynda, okay?
Okay, now, when we leave option number 1, I agree with Randy that I do not have very many clients when I do trusts personally that want their name in a land trust. But I do have some who don't mind. We put it in. So let's move to option 2. If the seller of the property sets up the land trust and then transfers the beneficial interest to you, now we're going to use option 2. Now think about what that says. That says, can we use Andrew as our seller?
Sure.
For those of you who don't know, I'm Andrew.
There's Andrew. Hi, Andrew.
Andrew is my marketing director here at Land Trust Made Simple. So he also sets up all the electronic and internet stuff. So he's here in the room, and we'll use him as an example too.
Okay, so Andrew is the seller. He sets up a trust. He already has it in a land trust because he knew about land trusts. So the seller sets up the land trust, or has set up the land trust, and now I want to buy it. I want to buy that piece of property. What does Andrew do? Andrew is going to sell me the beneficial interest. Now, there are lots of different ways that option 2 might be used. Some people use this particular option where there are more than one potential buyer, or there's a reason why somebody doesn't want to buy from trustee to trustee. So I can go to Andrew and I can say, I would like to buy the beneficial interest. Will you sell me the beneficial interest in your trust? And then we have to figure out, am I going to buy 100% of the beneficial interest, or am I going to buy a portion of it? So these are some of the situations in which the seller is going to sell me a beneficial interest. And in Randy's course, and especially I think it's in the advanced course, Randy, where you talk about different different situations where you're purchasing a beneficial interest or selling a beneficial interest out of
Right.
the trust, correct?
Right.
Is that the basic one?
Well,
Advanced?
I talk about it in the basic, but I provide the form, the contract to purchase that beneficial interest, and any default notices are supplied in the advanced course.
Okay, so let's go through this option. Now you're going to see it starts out fairly much the same. This trust agreement is made by Andrew, and Randy's going to be the trustee again in our example.
Okay.
So this trust agreement is made by Andrew and Randy Hughes as trustee. The real property, the trust estate listed in the schedule of trust property and attached hereto and made part hereof shall be held in trust. Now you look at that sentence, that's exactly the same as the one above it. The real property on the schedule of trust property is held in trust, da-da-da.
Yep.
So we're setting it up exactly the same, but now the parties to the contract here are different. The name of the trust created by this instrument shall be, and then we have the naming convention issue again. And that, as I said in option 1, Randy covers that quite extensively on how to protect yourself by naming the trust properly. I want to make a point here. Most states, when you record a deed, make you record it in the name of the trustee. So you might also want to think, and I know Randy covers this, you might want to think about who that trustee might be as to the name that you're going to use for the trustee. I have some people, clients, who name their trustee very differently, such as using a DBA rather than their own name. So Randy might go down and file a DBA, and he might become John Smith, and now he's the trustee. So we have a naming convention for the trust. You may want to consider a naming convention for the trustee as well. And I'm not going to go into that very much because Randy covers that pretty thoroughly in the class. So now the option 1 is the property's already in my name, and I want to buy it. I want to put it into the trust, and Randy's my trustee. Option 2, as a recap, is I want to buy it from Andrew, but what I want to buy is the beneficial interest. Now, option 3, which starts on the top of page 2. Did you want to make a comment on 2, Randy, before I move to 3?
Well, there was something I wanted to say, and I'm trying to remember what it was.
Okay.
Because you're buying directly from the seller in that example, instead of you being a current owner. The seller could be selling to you for all cash, or could be selling to you for financing.
Yep.
And of course, those would be 2 different situations. But in California, for example, let's use that as a good example here. If you had this Proposition 13 passed way back in the 70s, which limits the assessment of property and limits you to what, about was it 2.5% as far as increase in your
1 plus a little bit.
Okay, so you could have say an individual who's wanting to move out of a house that he or she has lived in for the last 40 years. They're going to move into assisted living, let's say, and their house is worth $2 million, but it's assessed for $300,000 because of Proposition 13 that kept the tax assessment so low, right?
Right.
So if you were to buy that house and pay $2 million for it, the tax bill would go from a $300,000 assessment to $2 million overnight, which would,
It's called change of ownership.
right, which would obviously destroy any cash flow if you were going to rent that property out, and just cost a lot of money even if you were just going to buy it to live in it. So if you had that individual put the property into a trust first, and then sell you the beneficial interest, either on installments or for cash, that the sale of that beneficial interest would be a non-recorded transaction and would avoid that reassessment. Am I right, Lynda?
Yes and no. If there is, for some reason, the county assessor looks at this trust, for some reason, how they would know about it, I don't know. The law says when you have an interest in an entity, any entity, and you are the beneficiary or you are the LLC member or whatever it is, and your ownership moves beyond 50%, that's deemed to be a change of ownership. So if you bought this on an installment, especially if you bought it in increments, you bought 10% of the beneficial interest and then another 10%, and you actually had a number of sales, you wouldn't be liable for the tax until after you owned 50%. The issue that you're talking about is that this is what I call the submarine transaction, where it's all below the surface and it's not seen. So the trustee, where the seller sets up the land trust, and the seller might even be the trustee. The name on the title at the county recorder doesn't change. There's something called a preliminary change of ownership form that has to be filed in California. And I know there are other states that have equivalent forms. I don't know what's called in other states. But that is something that you have to, when you change a deed, you have to file that preliminary change of ownership with the change of deed. And what Randy is saying is there's no change of deed, so there's no preliminary change of ownership that's reported to the county recorder. But just be aware that the way the law reads, it says it's actually very vague about trust because it says other entities. It'll say LLCs or corporations or things like that, partnerships. When you go beyond 50% change of ownership, you have to file this form. So that's an issue that's outstanding in California, and I don't know if it's the same issue that's outstanding in other states.
Okay.
But that's something that, if you're going to do that, just be aware that there is an issue. When that law says these business entities, corporations, partnerships, LLCs, and other entities, what does that mean?
Yeah. Well, the IRS doesn't consider a land trust an entity.
Right.
So I guess you could argue either side of that. But in the interest of keeping this broadcast at a reasonable length of time, can we go on to option number 3, please, Lynda?
Yeah, option number 3 is, I see it used a lot by people who don't want their name to show up anywhere. If you go back up to option 1 and just think about the fact that I, as the real estate owner, didn't mind having my name on this trust because my name is already in the county recorder. In option 3, you're keeping your personal name off the trust. So if you're working, like it says, if you're buying property from the bank as an REO or a lender, you can use this and have them transferred directly from their ownership to the trust, and you are the beneficiary. And I say you can also use this one if you already own the property and now want to transfer it into a land trust instead of using number 1. And basically that means you're not going to put your own name on page 1. You're not going to have it show. You're only going to show as a beneficiary provided that you aren't using an LLC, that you're using your own personal name. So here it says this trust agreement is made by and between Randy Hughes as trustee and the beneficiaries herein. On page 1, you don't see who the beneficiaries are. Now, a lot of times, I don't know what happened here in California, but escrow agents and title companies will take a look at a trust, especially if it says land trust, and determine whether they want to underwrite it for title. Well, how far into the trust do they really go? A lot of them go to page 1. So if your name doesn't appear on page 1, there's a trustee and beneficiaries. They never see that you were sometime in the past on the title. So this is more private. That's the difference. And then you'll see the next 2 sentences are exactly the same, as option 1 and option 2. So either when you're getting from a bank or a lender or REO or foreclosure or whatever, it can go right to the trust, or even if you're just going to put it in and you already own it, you don't even mention that you already own it. You just go right to the trustee's name. So privacy is more assured in option 3. I think, Randy, you said most of your students use option 3?
Yes, I believe they do. And before I get too sidetracked, Lynda, I would like to ask you if you don't mind giving out your email address and phone number in case anybody watching this would like to contact you
Sure.
for further help either in California or wherever. Would you mind giving that information out?
No problem. The email address is S as in Sam, M as in Mary, at lyndam.com. That's LYNDAM as in Mary.com. Make sure that it's LYNDA. If it goes to LINDA, I don't know who it goes to, but it doesn't go to me. So LSM at LYNDAM.com. That's my email address, and the easiest way to get a hold of me. Phone number is 858-750-3410.
Thank you, Lynda. Before we wind up here, there was another question that came through that we picked up on. The man says, I made the mistake of making myself trustee, and now I'm being sued. What do I do? So I'll make a comment, and then you can make a comment, Lynda. Obviously, this is a lesson to be learned. I always tell people not to be their own trustee, not only because in most states you can't be the trustee and the beneficiary because it's considered a merging of interest. Although Florida passed a law recently that does allow you to be both trustee and beneficiary. Why you would
Interest?
Yes. Why you'd want to do that, I don't know, but I assume there must be a reason. But it's obviously one of the biggest reasons for creating a land trust is for privacy of ownership. And if you make yourself the trustee, then that's not very private.
We would have to ask what the lawsuit was about.
Yeah.
Was this person sued as a trustee in the role of trustee? And does the person who is suing have any standing to sue the trustee? So I don't exactly know what the lawsuit is about. Is the lawsuit against the real estate? And then the trustee is protected anyway because you only have liability, which is limited to the real property that's held by the trust. But the trustee could be sued, for example, for breach of trust by a beneficiary or fraud.
Yeah.
I've had cases now where a beneficiary who's directing the trustee has breached a contract, and they were sued. I, as trustee, when I was serving as trustee, my Asset Century ALC has been sued for fraud, and I had nothing to do with it. The beneficiary has to indemnify you against situations like that. But when you're sued as a trustee, you need to think about, does that person have standing to sue you as trustee? What was their relationship to you? What did you do wrong that they're suing you for? Maybe they don't have any standing at all.
Yeah, maybe you didn't do anything wrong. In fact, obviously this person needs good legal counseling that we can't give without all the facts. But one thing that does occur to me right away is to resign as the trustee and try to get off that position as quickly as possible. Now, moving on, there was another question that came in, and if the person would retype it in, it was something about they were in Riverside County and wanted to know about contacting the county recorder's office. I don't know if it was prior about their rules of probably transfer, whether it's a transfer tax or reassessment upon transferring into a trust. So if that person would type that question in again, I'll read it, because when it comes across our screen, we only see it for a few seconds and then it disappears.
Let me make a comment on that.
Okay.
If you go to a hair cutter, you're going to get your hair cut, right?
Right.
If you go to a regulator, you're going to get regulated. So if you go to the county and ask the county, should I do this or should I do that, or does this happen or that happen? For whose benefit will the answer come? You've just exactly gone to a haircutter and you're going to get a haircut. So if you need to know that, go to your CPA or go to your attorney and ask that question. And you'll get an objective answer to the question. But I'm telling you, regulators are there to do one thing, to regulate.
Yeah.
And well, that's
Now,
what they're paid for.
Lynda, we just had, as you were speaking, a clarification come in on this lawsuit against the trustee issue. And the person said that they were being sued personally on another matter unrelated to the trust. And so obviously, they're wearing two different hats. So they can be sued personally, but if they get sued and they lose and get a judgment against them, it would not affect their position as trustee of the trust. Do you agree with that?
Correct.
Okay.
Serving as trustee, you're in a different capacity. You are actually considered a different person. You're acting as a different person. You have a completely different legal capacity. So you as an individual can get sued, but they should not be able to go against you as trustee.
Okay, we have gone a long time. I appreciate everybody sticking with us, and I do want to just reiterate the whole purpose of these scopes is so that the people watching these broadcasts can add to the real estate investments safely and have some privacy and some asset protection. And again, to reiterate that Lynda and I both suggest that you put each property into its own separate trust.
Absolutely.
And it's
Let me make a comment. The reason we went look today is because we attacked 3 options. And typically what we're going to do is just 1 paragraph, not 3.
right.
So other sessions will obviously be shorter.
Yeah, I appreciate that clarification. Many of the people watching are already part of that special group because special group meaning those people that are using trusts and putting each property into a separate land trust, because that's what I've taught for years, and I know you teach the same thing, Lynda. But if you're on this broadcast, you don't have our material, all this is new to you, you can get some free training from me by going to the following website and get a lot of information. It's a 1-hour presentation. It's called landtrustwebinar.com. That's landtrust, no S, landtrustwebinar.com, and I'll give you a complete presentation, and at the end of that presentation, you'll know more about land trust than 99% of the lawyers in the United States today. So I encourage you to go there if you haven't already done so. Also, for those of you who are subscribers to my monthly Land Trust University coaching call, here's a reminder that I'm going to be holding that next call this coming Saturday morning at 11 o'clock Central Time. That's 9 o'clock for you folks in California. It's noon for you folks on the East Coast. The coaching call, and those are recorded for playback at your benefit. In the future, as Lynda just mentioned, we're going to be explaining other paragraphs. We'll just probably take 1 paragraph at a time and break it down and maybe be on this scope for 20 minutes at the most instead of the 45 minutes we've been on now. Also want to ask everybody, if you want to be on these live Periscope broadcasts, send me an email and add me, that's ADDME, in the subject line, and send it to me, Randy, at MrLandTrust.net. That's Randy at MRLandTrust.net, and I'll add you to these Periscope broadcasts. And that way you can be on my email list too, because we send out notifications days in advance of the broadcast. If you don't get on this list, then you're only going to get an immediate notification from Periscope that the broadcast has started, so that's not much notice for you to prepare, get your notes out, and be ready to write. So you can follow me on Periscope and Twitter at Mr. Land Trust. You may have some friends and peers who would benefit from this information that we've taught here today, so a great way to strengthen and grow your network is by sharing this information with them. So let them know about these broadcasts. finally, I'd just like to thank Lynda again for your time, and we will get something scheduled for the next paragraphs here in the next couple weeks and let everybody know by email. So thanks again. Anything else you want to say, Lynda?
No, thank you, and we look forward to talking with you again.
Okay, thanks, folks. Talk to you soon.